Welcome everyone, and thank you for joining today's webinar entitled Federal Consultation Policies Working Towards Consent. This webinar is presented by NCAI, the National Congress of American Indians. For those of you unfamiliar with NCAI, this is an organization founded in 1944 by tribal leaders. NCAI is the oldest, largest, and most representative American Indian and Alaska Native tribal government organization in the country. Go to the next slide, please. Before we get started today, I'm going to go over a few basic housekeeping items and talk a little bit about expectations for today's webinar. First, because we want everyone to be able to hear the panelists as clearly as possible, all of you probably were muted on the way in, and we ask that all participants please remain on mute throughout this presentation. If you are using your phone for audio, please double check to make sure that your microphone is muted as well. Second, today's session will feature a Q&A session at the end of the event after the presentations have taken place. While we won't be answering your questions during the presentation, you are free to submit questions throughout the entirety of the event. So while the panelists are speaking, you may submit questions, and you do this by using the chat box, which is located on the GoToWebinar menu on the right. It should be the last item on your menu. You can enter the chat questions there. You can click on the top right portion of that chat box and move that chat box and make it larger if that's easier. We ask that when you do submit questions, you please reference the individual you're asking the question to, or if it's for everyone at the event, you can just simply put all panelists. That way we can direct the questions to the appropriate people when the time comes. As questions are submitted, NCI staff will review the questions, and we will get to as many answers as we possibly can. Due to limited time and the number of attendees at this event, it's almost certain that we won't get through all the questions. But we will save those questions, and we will do our best to address them after this event with an email, follow-up email to attendees. A couple of other quick points before we get started. Be mindful that what you write in the chat box is potentially seen by everyone in the webinar. It's a public space, although you can adjust who you're sending it to, but just be aware of that. And finally, this session is being recorded, and we do intend to place it on NCAI's YouTube channel shortly after it completes here today, so you can see that, or you can share that out with other people who weren't able to attend today. Next slide, please. With those housekeeping matters out of the way, let's turn to the agenda for just a moment. I'll start by introducing myself. My name is Ryan Seelaw. I'm a senior researcher with the Partnership for Tribal Governance at NCAI. In addition to myself, we also have Derek Spizzo on the call, who serves as NCAI's General Counsel, and Virginia Davis, who is a Senior Advisor and also the Director of Justice and International Policy at NCAI. And while you likely won't hear from them unless there's some sort of technology glitch, there's also a number of people on the back end helping us with technology, and we're very grateful for all of them. Without their help, this could not have happened here today. As we move forward through the agenda today, like I said, I'm going to take a few moments and provide a little bit of introductory remarks about why we're here today and what we're going to talk about. And then we will hear from our four distinguished panelists. After the panelists have all given 12 to 15 minutes of their time presentation, that's when we will be in the Q&A session that I mentioned just a moment ago. At the end of the webinar, there'll just be a few moments of wrap up, a few announcements before we adjourn. Next slide, please. So I want to begin by just taking a moment to ask, why are we here today? Why are we gathered to talk about tribal consultation at this point in time? And really the idea for this webinar came about after President Biden released his memorandum on tribal consultation and strengthening nation-to-nation relationships, which he released on January 26th of this year. In that memorandum, President Biden states that respecting tribal sovereignty and self-determination are a priority of his and of his administration. He also states that in order for the federal government to fulfill its trust and treaty obligations, that there must be regular, meaningful, and robust consultation with tribal nations. As part of this memorandum, President Biden also instructed all agencies to submit detailed plans of actions related to tribal consultation. He instructed those agencies to submit their plans only after consulting with tribal nations and tribal officials, and he asked that those plans be submitted within 90 days of the memorandum, which puts a date of April 26th of this year for when those should come out. Next slide, please. As you might imagine, fulfilling the requirements of this memorandum has resulted in a lot of action by federal agencies already. On this slide, you can see that more than a dozen consultation sessions are already scheduled for the month of March. And if you're familiar with your federal alphabet and all of the agencies, you can tell from the list that there's quite a few that are still missing from this list, which means that in all likelihood, in March and April, additional agencies will schedule federal consultations with tribal nations in order to adapt their action plans going forward. Next slide, please. So in response to the President's memorandum and the flurry of activity by the executive branch, NCI is working hard to assist tribal leaders and tribal nations during this time. And we're doing that in a couple of different ways. First, NCI is collecting and collating information about the consultation sessions. Specifically, we have recently updated the Consultation Support Center, which is located on our website. It contains all of the dates and deadlines that you saw on the previous slide, along with additional useful information. It also contains all of the policies, for instance, that the agencies currently have, the current policies, as well as announcements, a documentation that they've presented on consultation. In addition to collecting and collating information, we're providing educational opportunities and materials, for instance, this webinar. And we're also trying to provide space for tribal leaders to come together and decide how they want to approach some of these federal consultations. So for example, tomorrow we are holding a tribal leader caucus specifically designed to look at the Department of the Interior's framing paper and what they're going to do in the consultation sessions, which take place next week. Finally, as always, NCI will advocate on behalf of tribal nations as appropriate by our governing documents. Next slide, please. All right, and with that bit of background, I really want to turn it over to why we're here today and to our esteemed group of panelists. Just a reminder that while the panelists are speaking, you may submit questions in the chat to be addressed at the end of the session. And again, if the question is for a specific person, please try to note that in your question. Next slide, please. Our first panelist is Colette Rutel, who currently serves as the co-director of the Native American Law and Sovereignty Institute, as well as a professor of law at Mitchell-Hamlin School of Law in Minnesota. Prior to becoming a law professor, Professor Colette worked as a lawyer, where her focus was on representing Indian tribes and environmental organizations. She also has substantial experience practicing criminal law in tribal courts. She has published extensively, including on the issue of tribal consultation, which is what she's here to speak to us about today. Professor Rutel, thank you for joining us today, and the floor is yours.
Thank you to NCAI for inviting me to speak to you today. I've been tasked with giving a little bit of background on how tribal consultation came about, its origins and its history. And I'll try not to be a law professor in this discussion and to keep my comments pretty brief. As you probably already know, the trust responsibility has its origins in the early Marshall trilogy of cases in Cherokee Nation versus Georgia and Worcester versus Georgia. And when you look at the language in those cases, one of the things that Chief Justice Marshall said is that tribes could look to the federal government for protection, and specifically referred to protection in both of those decisions. Protection from what wasn't always clear, but you can see that there are pieces of protection from foreign nations, from state governments that are intruding on tribal sovereignty, and from US citizens who wanted to take away tribal land and other resources. In addition, in those cases, the Supreme Court talked about appealing to the federal government for relief of the tribe's wants. And so here there was an understanding that tribes were ceding large tracts of land to the United States, and with that, they were giving up their ability to continue traditional lifeways as they always had. And there was an obligation on the federal government to provide some services as a result of that. The relationship then that's created in the original Marshall Trilogy cases and then expanded on in several other cases is this sovereign protectorate relationship. So the dependency of tribes, which is referred to in the cases, is really actually tribal rights. It's a source of tribal rights. It says that the United States has a duty to protect tribes from foreign nations, from states, and from US citizens that are trying to reduce their rights and their property. And so from that, you can pull three substantive components of the trust responsibility. The first is a duty to provide services to tribes and tribal members, so the duty to provide education and health care. And once again, this comes from the acknowledgement that it's Indian land cessions that enable the growth and development of the United States. And so the federal government has a legal and a moral duty to provide those services, not just services that are specifically referred to in treaties, but services that are implied as a result of these land exchanges. The second prong or substantive component would be the duty to protect tribal sovereignty. And so again, the government has this duty to protect tribes as distinct political groups to prevent state governments from encroaching on their sovereignty. And you see this clearly in those early cases where the Supreme Court said that the law of Georgia could have no force or effect in Cherokee territory. And it was the United States' job and responsibility to ensure that. Today, we see this through things such as the United States bringing suit on behalf of tribes to protect tribal property or to enforce tribal interests. You also have a duty to protect tribal resources. And so this has a little bit more of a tortured history because the federal government early on took control of tribal resources. And obviously, today in the era of self-determination, tribes have control over their resources. And unfortunately, we have maybe a remnant of the prior control in the federal government making a lot of decisions, approval for tribes in terms of how they use those resources. But this is considered part of the trust responsibility, and there is a way to shape it in the modern era of self-determination to hold the government accountable for protecting tribal resources, particularly when third-party actions could harm those resources. If those are the substantive prongs of the trust responsibility, I think the consultation duty is a procedural prong. And so the idea of tribal consultation is that this is necessary to effectuate those substantive duties that the federal government has. So, for example, the federal government can't protect tribal resources. It more specifically can't protect tribal sacred sites if it doesn't know where they're located. And so consultation is required to identify the impacts that federal projects will have on tribal resources. Consultation is necessary to determine what services tribes need, and that can vary from tribe to tribe. So consultation is very important to identify how the federal government actually will go about complying with the substantive duties that the trust responsibility imposes on the federal government. Consultation is also important because unfortunately federal courts have proven really unwilling to enforce those substantive duties through direct lawsuits. So if Congress doesn't appropriate adequate money to provide health care for tribal members, courts have not been willing to reallocate funds or to compel Congress, nor do they believe they have the ability to do that. And when it comes to the duty to protect tribal sovereignty or the duty to protect tribal resources, it's really hard to figure out what the outer boundaries of those substantive duties are. So one of the ways to ensure that they have some force and effect is to really have a robust consultation requirement, even though it is a procedural duty. Where did consultation first start? I think the first example of tribal consultation for a congressional statute was probably the Indian Reorganization Act. And this is not a model of what we're looking for tribal consultation by any stretch of the imagination. The IRA was prepared in draft form by John Collier in his first year in office in 1933. And then he held a meeting with some private organizations and church groups that were interested in reforming the Indian service in January of 1934. He pretended that what happened in that January meeting led to his development of the legislative proposal, but historians have been able to show that he had his ideas well fixed before that January meeting and had put pen to paper already. In February of 1934, he introduced his bill in the House of Representatives. And it's only at this point that he said he would hold congresses in locations across the West to consult with Indian tribes. So it's not a great example of tribal consultation because consultation isn't coming until after the bill has already been written and introduced into Congress. One way that it is a good example of consultation, though, is that there was so much pushback in those Congresses with respect to the scope and structure of the IRA as it was originally introduced, that it did result in revisions to the bill. So while the IRA is not a good model of consultation, I think it is the first example of federal officials seeking tribal input on federal statutes, and that input having some impact on the final statute as it was adopted. Things were quiet on the consultation front, though, until the 1950s, when Congress started aggressively pursuing its termination policy, and this organization, NCAI, launched an offensive to try to stop that. And so in 1954, NCAI's Declaration of Indian Rights specifically stated that tribes needed to be informed about and consulted about federal policies that could affect their rights. Unfortunately, it wasn't for another 15 years that the federal government began to seriously consider tribal consultation. And we see that in the 1970s. There's a shift to the era of self-determination. And we see the first federal policies that are requiring consultation. And they arise in the context of the substantive duty under the trust responsibility to provide services to Indian tribes. So in 1972, the BIA issues a policy called Guidelines for Consultation with Tribal Groups on Personnel Management within the BIA, and specifically required consultation when making decisions such as deciding who the area director should be or who other federal officials should be. This was very limited. It was limited to personnel decisions in the Bureau of Indian Affairs, but it is the first consultation policy that exists. Then in 1975, we see Congress for the first time enacting a statute with a consultation provision, and that's, of course, the Indian Self-Determination and Education Assistance Act. It required tribal consultation with national and regional Indian organizations when the regulations implementing the act were drafted and any amendments to that. And then after that, you saw the 1978 education amendments that required Indian tribes be actively consulted in planning and development of Indian education programs. So these are really the first consultation provisions that you see in federal law. Congress then steps in and starts enacting a lot more of these requirements in federal legislation in the late 70s, 80s, and 90s, primarily now in the area of the substantive duty to protect tribal resources. So you see a consultation requirement in the Archaeological Resources Protection Act of 1979, in NAGPRA, the Native American Graves Protection and Repatriation Act in 1990, and importantly in the National Historic Preservation Act in 1992, the amendments. These statutory provisions will still always be very important to tribes because when this consultation duty is memorialized in legislation, this gives tribes an enforceable right in federal court. And so we have seen that the meaningful federal litigation can be conducted if consultation doesn't occur, if Congress has memorialized that responsibility in a federal statute. But all of these statutory provisions are pretty limited. They're limited in scope to the statute that they involve, and so consultation in particular substantive areas. It wasn't until the 1990s and President Clinton that we saw consultation become much more widespread, and this was through executive orders. So in his first year in office, President Clinton issued two executive orders and enhancing the intergovernmental partnership required consultation on certain federal proposals. Then there was a 1994 memorandum, a 1998 executive order, a 2000 executive order. I'll refrain from going through the specifics there. The point is, by that ending date in 2000, consultation is basically required on most things that the federal government does, on notice and comment rulemaking, on legislative comments, on proposed legislation, on policy statements and actions that have substantial direct effects on Indian tribes. The limitation, or one of the limitations of these executive orders, unfortunately, is that they don't create enforceable mandates that if they're not followed, tribes can bring a suit in federal courts to compel the agency to actually engage in consultation. And they typically expressly disclaim those substantive rights. In 2009, President Obama then passed a memorandum, or adopted a memorandum, saying that his administration was going to follow Clinton's executive order, and also required agencies to develop their own consultation policies. And that is basically what President Biden's administration is doing as well, too, is requiring agencies to adopt their own consultation policies. So I think Kim Tihi is going to go into a lot of depth on the President Obama's implementation and some guidance moving forward. There are a couple points that I want to raise that I think would be helpful to think about while agencies are crafting consultation policies. The most important thing is, what does consultation mean? Is there a definition in the policy about what consultation means? And this is important because I think from the tribal perspective, for the most part, most tribes would like consultation to mean consent, that tribes have an opportunity to consent to a particular project or proposal. And on the opposite end of that spectrum, some federal agencies in the past have sometimes thought consultation is just notice. That if they post notice in the Federal Register of some rulemaking, then that's good enough to have consulted with tribes. Somewhere in the middle, but more towards the notice end of the spectrum, what I've seen frequently in my practice is that agency officials are just checking the boxes. So they're cataloging every time they send a letter to tribal officials, or every time they place a phone call, or every time a tribal member or tribal leader is present at a particular hearing, and they're cataloging that in this giant spreadsheet and saying, look at all the consultation we've had, when none of those individual actions really, in my opinion, would rise to the level of consultation. So what should consultation be if tribes are not able to get to the endpoint that they probably want, which is consent? Perhaps it's a definition that says attempting to achieve consensus or consent. Making good faith efforts to achieve consensus or consent. And at least it means listening to tribal concerns and attempting to find ways to address those concerns in your action. But a specific definition, I think, of consultation is really important in each one of these policies, as is trying to figure out, are there structural ways that we can ensure that consultation happens as opposed to just notice and comment, which is what everybody has a right to do in the United States when agencies take action. And so one example of a structural way might be allowing tribes, stating specifically in the policy that tribes should be cooperating agencies, for example, whenever possible in federal projects, and specifically indicating when that's possible under NEPA and other federal statutes. I can see my time is already coming close to an end, so I'll move through some other suggestions really quickly, and hopefully we'll have time to discuss them in questions. I think obviously I'm going to kick this to my co-panelists. What actions require consultation? This is a huge problem because the federal government takes so many actions on a day-to-day basis. It really becomes overwhelming for tribes to receive all of these notices of various federal actions. I think we just saw in the PowerPoint slide, it's overwhelming just to think of all those consultations on the policy to consult with tribes happening in the month of March. So figuring out in some way how to pull out from that mass what the actions are that really require tribal attention, and providing some funding to tribes so they can actually provide that attention. When does consultation need to occur? I think for these policies, everybody always agrees that consultation needs to occur as soon as it possibly can. But consultation isn't just about project rule consultation. There should also be something in the policy, I think, about periodic consultation with each agency to make sure that there is a check-in at various points with top agency officials, so you can evaluate how consultation has been working and how the agency has been working with the tribe. And last I'll say is, who's involved in consultation? A lot of times tribes would like to see high-level agency officials involved in consultation. And yet there's some confusion at federal agencies and projects that I have been involved in. I've sometimes seen the hired contractor on a NEPA case being the one that is sending out consultation letters and thinks that they're conducting the consultation, even though they're not actually even an agency employee, let alone somebody with decision-making authority within the agency. So I will stop there for now and hope that we have time for questions afterwards.
Thank you very much, Professor Rutel. I think that was a very good background, historical and legal background leading into our next three panelists, where we'll hear from the White House perspective, a federal agency perspective, and a tribal president perspective. Also, thank you for your thoughts on what can be improved. I do hope we get to some more questions on that. As we turn to the next presenter, it's always a privilege to be able to introduce a fellow University of Iowa law alum, like our second panelist here today, Ms. Kim Tihi. Ms. Tihi currently serves as the Director of Government Relations for the Cherokee Nation and the Senior Vice President, she's the Senior Vice President of Government Relations for the Cherokee Nation businesses. Prior to working for the Cherokee Nation, Ms. Tihi held many distinguished positions, including serving as a Senior Advisor to U.S. House of Representative Dale Kildee, and serving President Barack Obama as the first ever Senior Policy Advisor for Native American Affairs in the White House, where she was instrumental in drafting President Obama's 2009 Memorandum on Tribal Consultation. Ms. Tihi, thank you very much for joining us today, and I turn it over to you now.
All right, can you hear me now? Awesome.
Yes, we can.
Thank you. Thank you, Professor Rutel, for laying that foundation too. In 2009, when I joined the White House Domestic Policy Council, I knew that the Executive Order 13175 on tribal consultation, which was signed in the Clinton administration, was not regularly being enforced in the administration before the Obama administration. To change that, I had proposed early on that we actually make revisions to the Executive Order. And then I had a meeting with President Obama, and he asked me flat out, if the executive order has not been enforced, then how do we know what changes are needed? And he was right. I could make an educated guess and figure it out, but really I didn't know. And so it was actually his idea to say, what if we instead signed a memorandum where I direct all the agencies to comply and with the executive order, and let's see what happens. The idea was, let's have a team kind of environment. Let's have people who are motivated to want to consult and work with tribal governments. And so, so I wrote the 2009 presidential memorandum with the OMB Council at the time, and we actually consulted. The challenge for me was, how do I consult on consultation without letting the cat out of the bag that this is what I want to do? And so I oversaw consultation sessions, and stemming from that, naturally tribes wanted better consultation. And so we did that. And I focused a lot on the meaningful aspect of consultation, that the consultation be meaningful, just like President Biden's memorandum that also focuses on regular, meaningful, and robust consultation. So I want to kind of go through some of the lessons learned and how maybe the agencies can adopt these standards just from lessons learned. Internal collaboration is important. This means that many senior level political appointees in the administration who want to do good, but they don't know enough about tribes. So they don't have the substantive expertise on tribes or consultation. So I think this is what's going on now, which is, there has to be sort of these 101 sessions, Indians 101 sessions, consultation 101 sessions. And also, I'm sure these agencies are clamoring, trying to figure out how the heck do we put an agency plan together on consultation. I know, because I was a recipient of a lot of those phone calls and had those binders of agency plans on how they plan to consult. The other piece is agency restructuring to improve consultation took place. This means establishing dedicated offices for Native American affairs at the cabinet secretary level across the various agencies who can oversee not only tribal issues, but also consultation. when I left the White House, there were 8 agencies that had Native American advisors in the cabinet secretary offices. And 7 of those agencies also developed tribal advisory groups. You know, many of us are familiar with HHS's STAC. That grew out of Secretary Sebelius wanting a tribal advisory committee. And those don't replace consultation, but they certainly allow at a very high level for tribal representation to be had whenever these decisions are being made within the agencies. Another area is multi-agency collaboration on consultation. Agencies can coordinate and combine their resources for consultation. You know, we are seeing all these agencies engage in consultation, and they can all actually collaborate. Wouldn't it be awesome to see the heads of each of these agencies engaging in a virtual format with tribal leaders on consultation, so Indian Country is seen at a very high level, this multi-agency collaboration on this very topic. You know, it doesn't, again, replace each individual agency's efforts, but it certainly would send a very big signal to Indian Country if there was this multi-agency collaboration on the consultation policy itself. I mean, when I was in the White House, I oversaw the consultations on the United Nations Declaration on the Rights of Indigenous Peoples. I know this is an area that's near and dear to President Sharp's heart, and I was able to get 14 agency, very high level agency participation in those consultations with Indian Country and with NGOs and such. And so I think, you know, you choose the issue where it makes sense to pull in agencies at a high level. It also mitigates consultation fatigue, and it also helps with the combined resources for those agencies who haven't maybe planned for consultation. So I also think included in that, with the upcoming president's budget, they all need to be adding consultation costs to their budgets. Use of diverse venues, obviously, I think we all know what that means. It's consulting at NCAI or other issue-specific organizations, whether it's NIEA, NIHB, and on, and even ad hoc consultations. And when I was again in the administration, USDA was awesome about taking on individual tribal consultation requests. And so those were always a good thing. Something Professor Rutel hit on too is something that I've often been kind of bothered by, which is there is no uniform definition of what consultation is. And if you ask an agency lawyer what it means, they're going to take the most narrow form of what it means. That means, you know, one-on-one phone calls, responding to emails, and, you know, sometimes they will say that's consultation. The problem with that, if that alone is what's driving decisions, those aren't meaningful consultations. And so laying a groundwork for what meaningful means to Indian Country and what it means in a memorandum that a president signs to be meaningful, that it be widespread, and that there actually is input coming into all this. Which leads me to another area, which is for agencies to develop strategies for reporting the outcomes to tribal leaders as a result of those consultations. I mean, how wonderful would it be, for example, to have the White House Council on Native American Affairs reestablished and to consult on the first early part of the year, and at the end have a tribal nations conference with a progress report that says, look at all we've done, based upon not only the first session, the first part of the year, but all throughout the year, based on the things that we've heard from Indian Country. Look what all we've done as an administration to respond to the things that you've said during these consultation sessions. I think that would be a wonderful way of showing Indian Country that their input matters. But one of the things that I recall hearing is, and I never addressed properly, is, in my opinion, is reporting the outcomes. Some agencies want to do it, some don't, you know, because they're just, you know, concerned that they may not be doing enough. But I do think Indian Country, at the end of the day, want to know, you know, what happened to all the things that we said? How is it reflected in the policies that we talked about in these agency discussions? I think use of technology, especially now in the COVID environment, obviously we know that there are connectivity issues and there are, you know, these digital divides that exist, but email, teleconferences, video conferences, social networks like Facebook, even I would suggest an interagency portal so that the agencies themselves can consult each other on consultation. They can information share, they can discuss best practices. It's a way to be better internally, I think, is something that is worth mentioning here. What else can happen? I think Indian country obviously has a role to play here, is in making consultations meaningful. So that means making sure that when you are facing, agency officials, that you know what you want to say. Yeah, you identify the problem that you're seeking to address, and that you've maybe come up with some recommendations on how to best resolve that. I think the best example I have of this is the very first White House Tribal Nations Conference. If you recall, the Affordable Care Act was at play, and President Obama was doing these town hall formats. He wanted the Tribal Nations Conference to be a town hall format, and where the Q&A is not choreographed. He wants to just pick people from the audience and have them ask a question. That made my job real fun, because my job was to create the memorandum of all the cross-cutting issues that could possibly come up in this kind of format, and to prepare, background plus potential responses to each of these issues. So, but what happened, he was excited. He was excited about this because, he had been briefed, he read all of his material, he's prepared. Here's what happened. Speaker after speaker got up and read a statement. And so, which is fine that the statements are being read, but we should have been prepared to ask questions. This is an issue that we're facing. We'd like for you to resolve these issues. We're getting, just identifying the problems that we're seeking to address. So it led me to believe too, that we have spent so much of our time as tribes and tribal advocates trying to get a seat at the table, that we also have to learn, once we get to the table, what do we do next? How to play in that game. And so I think that is also an area. Another area that I think is important is that these consultation sessions be truly consultations of dialogue, not listening sessions. I mean, I heard complaints. I still hear complaints about listening session. I just participated in an agency-led consultation session on consultation, and I heard very little feedback from the agency officials. And I think that that can be frustrating for a tribal leader who wants to know that they've been heard, and that there's dialogue coming back, and that there's a meaningful engagement that's taking place. And so I do think that is also an important piece of teaching. And you have to teach, we have to teach the agencies how to do this, because this is not their area for the most part. And so what I would do is I would run some consultation sessions out of the White House. And for agencies, in order to try to spur dialogue, we would do some FAQs. Let's talk about some of the, concerns of Indian country, which by the time you have a consultation session, you probably know kind of what Indian country is going to talk about depending on the topic. And so you can pretty much figure out what the FAQs are going to be. It's like, if you're asked this, then these are potential responses back. But the dialogue needs to take place. It can't just be listening session. It's got to be meaningful consultation. And to me, that's a two-way street. And the reason I mention all this is that, we're in the midst of, watching Congress pass a massive rescue package, where Indian country is going to have a massive amount potentially in that rescue package, to the tune of $20 billion. And we know that Treasury is going to be responsible for dividing out those resources. And we know that consultation will be had. There will be, in my opinion, a stark difference between how this administration consults on how to distribute those funds versus how the previous administration consulted to distribute those funds. And so my hope is that it's a stark difference, that it's a more meaningful dialogue, and that it's productive, and that we see Indian country's concerns reflected in the outcome of ultimately what that decision is out of Treasury. But that's just one example. We will see this in the infrastructure package, climate change packages, and on as this administration, which is being very aggressive in its executive actions on how they want to consult. We just want to make sure that we're not only at the table, but that we are at the table in a meaningful way, and that we have clear, concrete suggestions and when we're invited to participate in those discussions. And I'll stop there.
Thank you, Ms. Tihi, for sharing your unique perspective from your time in the White House, and for sharing just a lot of really interesting and good ideas that, again, hopefully we will get to more of in the question and answer, but that was really valuable. Thank you. Before I introduce the next panelist, I just want to remind everyone that you can submit questions in the chat as we continue. So as people are talking, please continue to submit those questions, and staff is reading through those as we do that. So our third panelist today is Mr. Michael Connor, who is a partner at WilmerHale Law Firm, where his practice focuses on natural resources, energy development, environmental compliance, and Native American law. Prior to this position, Mr. Connor held many distinguished positions, including serving as the commission of the U.S. Bureau of Reclamation, as well as the Deputy Secretary of the Department of the Interior under Barack Obama. We are incredibly fortunate to have him come here today and speak to us about tribal consultation from his perspective. So, Mr. Connor, thank you for being here, and the floor is yours.
Great, thank you very much, Ryan. Can people hear me? I'm on. This is great.
Yes, you're on.
Thanks for the introduction. Thanks to NCAI to having me as part of this very distinguished panel. President Sharp, thank you very much for all you do for tribal nations across the country, as well as your own tribe, and Kim and Professor Rutel. It's great to hear your perspectives. So I will try not to repeat those very wonderful perspectives and very helpful, I think, to the tribal consultation process that's now rolling out. But maybe I can add some thoughts based on my experiences, particularly at the department. Typically, when I talk about tribal consultation, I usually start a lot of these discussions I've had in the context of the Colorado River Basin and the history of tribes' involvement or lack thereof, quite frankly. And I always kind of characterize it as periods of different ways the federal government has engaged or not engaged with tribes. And I think it's important to remember that, because as I've given this talk at times, I would say the periods are not sequential. There are different modes for how federal agencies and the federal government has dealt with tribes on issues that are fundamental to the tribal treaty rights and interests. And it's not been a steady process of improvement, particularly as we've seen in this last administration. There is the period of adversity. After conquest and treaty making, there's been a whole period of really the federal government at odds with tribes, notwithstanding the duties that Professor Rutel laid out, at odds in defining the scope of tribal rights and interests. And that even happens today with respect to the Dakota Access Pipeline litigation and the very narrow interpretation of rights of tribal rights that the Army Corps of Engineers had moved forward with in carrying out their NEPA process. There is the just ignoring tribal rights and interests in carrying out interactions with other entities, such as negotiating, whether it's the Columbia River Treaty or the Colorado River Compact, failing to understand the implications to tribal interests of those actions. Then there's the period of consultation, as outlined by my two predecessors here, particularly kicked off with President Clinton's executive order and the process of consultation, in some cases meaningful, robust, in other cases meaning being informed just prior to the press being informed of a decision that's already been made. And so consultation has run that gamut. Sometimes it's been very good, sometimes it has been merely a check the box exercise, as described earlier. But I do think now we have embarked in a period during the Obama administration and now in the Biden administration where it's true integration. How do we get to integrating tribes in the development of federal policies or molding how federal actions are taken, whether it's permitting on infrastructure projects or just basic policy development that affects tribes? And I think we're on the cusp of seeing once again how we can take the next step from that executive order in 2000, from the presidential memorandum by President Obama in 2009, and take the next big step in improving in the tribal consultation process, whether it's understanding what that means, ensuring better defining the terms robust, meaningful, substantive engagement with tribes. What does that really mean, and how does that affect federal decision-making processes? So to get into that, I want to step back into the Biden campaign, in which promises were made, in which policies were set forth that President Biden and Vice President Harris would implement upon taking office. And thankfully, they are in office at this point in time. And there was a lot of processes, whether it be in the platform of the Democratic Party that was outlined at the convention that addresses tribal consultation. And then there was the Biden-Harris plan for tribal nations that was released in October before the election. They committed to promoting robust and meaningful consultation with tribal nations. And in outlining what that meant, it was the desire of President Biden to reinstitute the consultation mandate that was set forth in the executive order by President Clinton, as well as the 2009 presidential memorandum, and to require consultations to be consistent with the RESPECT Act that Chairman Grijalva had introduced, or at least circulated a draft of the RESPECT Act to better define those tribal consultation processes from his role as chair of the House Natural Resources Committee. And I thought that was very meaningful that the campaign committed to working towards consultations that would be consistent with that act. And that means substantive engagement, and that means expanding consultation to all agencies and independent, to all agencies across the federal government, as well as the independent agencies that exist. And so I think that leads to very significant opportunities. We are not yet there in the executive actions that have been taken to date with respect to the presidential memorandum that was described earlier, that was released on January 26th. But I do want to say, based on my experience in thinking through how tribal consultation processes have been carried out, quite frankly, it's been a personality-driven process. There have been broad parameters of the requirements of consultation. You've heard from myself and others how that varies and how it's actually implemented, from the check the box exercise to low-level interactions with tribal officials, to very good processes leading to modifications or changes in how the federal agencies develop policies or carry out their permitting processes. And we need to get out of personality-driven. It's great when you have an administration that comes in that appoints, as Kim mentioned, a lot of people who really want to do right by tribes, who really want to carry out meaningful tribal consultations. And sometimes they're very well informed on the unique relationship that the federal government has with tribes, and sometimes they're not, but they're willing to learn. And sometimes they don't know and they don't carry those out. So we've got to get to some level of consistency, and we've got to get to some level of institutionalized processes where there's a, raise the bar as to where the floor is, and then the ceiling can be as high as it can be with federal officials who get it, who understand, who really integrate tribes into decision-making processes. And so I think that's the opportunity that we have now, based on the processes that have been set forth in the presidential memorandum that was issued in the first week of the Biden administration. So it reaffirmed the requirements to have updated plans that was set forth in the 2009 presidential memorandum. It requires the implementation of policies consistent with Executive Order 13175. And then it lays out a series of these next actions, which is the process that many of you are in the middle of right now. By May 1st, or as Ryan set out, April 26th, we should have detailed plans of actions from all the agencies and departments that are set forth. Then by later this year in November, there should be a progress report on those plans. What did they say and how have they been implemented so far? And then what I think is a very, very significant step in this process is a year from now, so by February of 2022, there are supposed to be recommendations coming out of the White House based on the plans, based on the progress reports, based on the ongoing consultations of how to make tribal consultation more effective for the long term. And I think that's really the opportunity to say, how can we better define that consultation process, and how do we move forward in a way that makes it sustainable in the long term and not have it dependent upon who's in the administration, which party is in charge, who are the personalities that those different administrations appoint to these positions. And so I think, the bottom line, I think this is going to be talked about more. I think the gold standard for a lot of tribal leaders and tribal entities are, how do we get as close as possible to free and prior informed consent? as it was set forth in the UN Declaration on the Rights of Indigenous People, free and prior informed consent would be the right to review, change, approve, or deny any proposed government action that would impact tribal lands, rights, or sacred sites. So it doesn't mean just limited to tribal lands itself, to reservations, to lands in which, or any resources in which tribes hold an interest. It's any government actions that would affect those interests. And that's going to be very difficult to get to that point. From my perspective, there's a lot of legal issues associated with giving tribes essentially a veto over a number of different types of actions. But how close can we get, at least, to getting to that gold standard? And how do we ensure that there's long-term protections as part of that process? So once again, I think the process that's playing out this year and the consultations and the plans that come out, and then seeing over the next year how those plans are turned into recommendations to improve that tribal process is going to be very significant. Just a couple of final points I want to make with respect to reminding ourselves of where we've been, because there have been 2016 in the aftermath of the Dakota Access Pipeline issue becoming very visible across the country, and the commitment to go back and redo the EIS that was made by the Obama administration. There was also a parallel commitment to consult with tribal leaders on the infrastructure, federal infrastructure permitting process that had been in place. During the Obama administrations, there had been a lot of effort to streamline, to expedite permitting processes consistent with the administration's priorities, particularly related to clean energy, et cetera. But that had implications on tribal interests. So the idea was, how do we ensure we can improve the consultation process, even as we try and get to more efficient permitting processes, and integrate that with keeping a substantive approach to tribal consultation, meaningful tribal consultation. That resulted in a report that was issued in January of 2017 before the administration left office. A couple of key points that were highlighted in the executive summary was there needs to be consultation sooner. There needs to be training, I think, as all of our panelists have noted, training of staff on understanding the rights and the relationship that the federal government has with Indian tribes, because that's not a consistency across the agencies, and that there needed to be consistency across the agencies, recognizing that, you know, for a large part, this had been a personality-driven process. I participated in a lot of those consultations during that process. I heard a lot about free and prior informed consent that was not incorporated as part of the recommendations in that report that was released in 2017, but it was certainly on tribal leaders' minds at that point in time. Second, I think it's important, and I went back to the campaign just to highlight the reference that was made to the RESPECT Act. And the RESPECT Act, the scope of the RESPECT Act is a little different than the executive order that currently exists that everybody's committed to, which is basically consulting on any federal policies with implications for tribes. The RESPECT Act was a little bit more specific about detailed, robust, substantive consultation requirements, creating a record of those tribal consultations and the response to tribes associated with actions that affected tribal cultural resources and tribal lands and the federal trust responsibilities. So the scope is a little different, but how close can we get to that procedural guarantees that exist for tribes that are outlined in the RESPECT Act that ensure that it's not a check the box exercise, it's listening and it's responding to tribes, and it's responding with how those interests have been addressed, whether it's mitigating actions that are being taken by the federal government, or whether it's changing, or whether it's denying actions that have been requested of the federal government. And I think that gets to the question of how ultimately will this process lead to meaningful long-term change in the consultation process. In my last point, I would just note that tribes should also be thinking about other commitments being made by the administration. In the executive order on climate change, there is repeated references to tribes and the requirement to engage for substantive engagement with tribal nations as well as other disenfranchised communities on a number of the actions contemplated as part of the president's climate change agenda. That is another way to address tribal interests through that process. I think they'll need to be ensured that tribes are just not another disenfranchised community, that there is a relationship that exists between tribes and the federal government that's different than other communities. But it's an opportunity to engage. It's an opportunity to ensure as tribal leaders that you can go to agency officials and said, your boss, President Biden, committed to these processes, and it's your responsibility to carry them out. And that goes from everything to just the decisions being made to the environmental justice plans that are being set out to the Justice 40 initiative, which is the idea of investing at least 40% or securing 40% of the benefits of clean energy, clean water investments accruing to tribal communities as well as other disenfranchised communities. So there are other ways to engage in this administration. I think it's important to understand the whole set of tools that tribes will have at least over the next 4 years and hopefully longer to highlight their interests, to engage federal agencies and have those federal agencies respond in a substantive way. So with that, thanks for the opportunity and look forward to the dialogue.
Thank you, Mr. Connor, for sharing your experiences and your perspectives today, and also for highlighting some of the opportunities for tribal nations that are coming up. Our final panelist today is Fawn Sharp, who currently serves as both the president of NCAI as well as the president of her own nation, the Quinault Indian Nation. President Sharp was elected as NCAI's president as the 23rd NCAI president. Prior to her current leadership position, she served in a number of other capacities, including as an attorney with her own nation, an administrative law judge for the state of Washington, Department of Revenue, and counsel for Phillips, Krauss, and Brown. She has also done historic work in the area of consultation and consent within the state of Washington, and we are honored to have her here today to share about her experiences and what is possible moving forward. President Sharp, thank you for joining us, and the floor is yours.
Great, thank you. Thank you, everyone. First of all, before I begin my remarks, I just want to say thank you to all of our panelists. This is quite engaging, just a way to orient us to having the tribal leader conversation, laying the foundation, laying the history. I really appreciate that. And the photo there on the screen just caught me off guard a bit. That was the day I got elected in 2006, nearly 15 years ago, March 28th. And I looked much younger and very idealistic at that time. And it's interesting when you go back to when you first get elected as a tribal leader, the thoughts and the vision and the enthusiasm and inspiration you have. And over the years, I've just found that my enthusiasm just continues to grow, and I continue to see the opportunity and the potential and the responsibility of our generation of tribal leaders. And so I thank you for just that gentle reminder that this has been a long journey, but we still have just an incredible amount of opportunity right in front of us during this administration. Before I get into some of the points I wanted to emphasize on this webinar, I thought it might be helpful just to provide a little bit of background as to how I came to working on the issue of consultation and free, prior, and informed consent. So as an attorney for my tribe, I was in my office one morning, afternoon, and our staffers from our Quinault Division of Natural Resources called and said there are some Russians, visiting Russians here. They want to hear a little bit about our legal system. And so they said, could you come up to the office right now and talk to them? And so I left my office and had a conversation. When I walked into the room, I was expecting to see tall Russians, and there were short native Russians from Northern Siberia, indigenous peoples. And about 10 minutes into my conversation, I found, even through an interpreter, I just had this instant connection with the indigenous peoples from northern Siberia. And it led me to research, realize, and understand that there are hundreds of millions of indigenous peoples globally. And I learned probably more from them than I was able to teach them just in that short period of time about our legal system. That led me on a quest to study and pursue international human rights law. That was the fire that ignited that within me as an attorney. And of course, back then, I had no idea that I would be running for elected office within half a decade after that. I studied international human rights outside of this country, and I had an opportunity to engage with students from 30 some other countries. And I really got into the history of international human rights law with a focus on indigenous peoples. Now, during that time, that was in 2003, it was the UN International Decade of Indigenous Peoples. And there was a goal, and I found out in my studies at that time, there was a goal to adopt an international declaration on the rights of indigenous peoples. It was a work in progress. I learned about free, prior, and informed consent. I was excited that this could be the opportunity for us as sovereign tribal nations to globally be able to exercise the full spectrum of tribal sovereignty. All of those cases that I studied and had a working knowledge of as a practitioner, all the barriers. I mean, it just occurred to me that every bit of our relationship with the United States is born out of contention, born out of litigation, born out of all kinds of an adversarial relationship. And here is an international standard, a declaration that articulates a minimum of what a country should recognize with respect to the rights of indigenous people. So I was very excited toward the latter part of my legal career. And the year I got elected, that was in 2006, the following year, the UN took a vote on the Declaration on the Rights of Indigenous Peoples. This was under President Bush at the time, and I think it was 144 countries voted to support these fundamental basic principles on the rights of indigenous peoples, and 4 countries opposed: Canada, Australia, New Zealand, and the United States. And so that was the first year I had as a tribal president. I was really disappointed that we'd worked, and there were a number of tribes and probably people on this call that remember those days of working long hours in crafting, in decades really, in crafting these minimum standards. And so as Kim pointed out, when President Obama got elected, there was an outreach. And at the time, I was a young president. He wanted to have a consultation session, a listening session on President Clinton's executive order. I didn't want to go to the White House and complain. I wanted to identify the weaknesses and then come to the table with solutions and recommendations. And one of the key points was there is no dispute resolution mechanism with the United States other than litigation. If we have a dispute with the United States, the only option and remedy we have is filing a lawsuit. And if you look at some of the other records and documents that we have at NCAI going back to the mid-70s and the American Indian Policy Review Commission, there's another problem with that, and that is there's this inherent conflict of interest. If we pursue treaty conflicts and if we bring litigation, there's an attorney from the Department of Justice and there's a solicitor. So it's the United States arguing against itself. There's no independence, and there's this inherent conflict of interest in all treaty conflicts. And so we wanted to propose a redefined framework. And that brings me to this subject matter that's part of this webinar. So we need to understand some basic principles. Our relationship is not with the Department of Interior or the Department of Health and Human Services. It's not with agencies. Our relationship is with the United States, and how we engage with the United States is what is so critically important to understand some basic foundational principles, and that is what I call political equality. And that also speaks to the issue of what is meaningful consultation. From my perspective, looking at consultation from a tribal leader perspective through a sovereignty lens, it's a basic principle, and that is No other sovereign should be able to take unilateral action affecting our land, territories, resources, and people within our territorial jurisdiction without our consent. It is not, it is a violation of fundamental principles that weren't given to us. These are inherent rights as sovereign indigenous peoples on our sovereign lands within our territories that we've reserved by treaty. And it's a fundamental principle that is accepted globally. And it's a standard that is accepted globally. These are inherent, basic sovereign rights. And so if we accept that basic principle that no country should be able to take unilateral action, that means they must have our consent. And anything short of that, it is a relationship that from the very beginning puts us in a position of unequal bargaining power, unequal leverage. We are not sitting at the table in a government to government relationship with political equality. And that is the challenge that we are facing. Now, do I think we're going to achieve that full spectrum of political equality under the Biden administration? As was pointed out by some of the earlier speakers, that's a pretty high standard. That's a pretty high, a lofty goal. But we need to recognize that this is a generation after generation. And what can we do as this generation of tribal leaders with this administration to continue to push and advance a basic principle that we know to be true? And so from my perspective, I think we all, in engaging with this administration, need to advance a foundation of minimum standards, and that is no unilateral action without our consent. And we need to say that aggressively and widely in every consultation session that we have. And we need to stand on not necessarily the laws and the policies and the conflicts and all these things. We need to stand on what we know to be true, and that is the inherent attributes of sovereign tribal nations. And so that's the first point I wanted to make. The other point I really wanted to emphasize in this webinar is we need to understand that not only do we have an agenda as sovereign tribal nations with this administration on consultation through a lens of domestic policy, there's this other layer of international and foreign policy on the rights of indigenous peoples. And we know that this administration is very eager and is looking toward how they can improve their international and global leadership on the issue of human and civil rights. We also know the entire world has witnessed what's gone on here in the United States, and that we are being torn apart domestically on the issues of race equity, on civil rights, on human rights. And we want to restore that leadership role globally. And we know that when President Obama embraced and reversed the position on DRIP, he made a statement that the United States should be a leader globally on implementing the UN Declaration on the Rights of Indigenous Peoples. Now, back in those days when I was a tribal president, I didn't want to wait to find out, okay, what is President Obama's vision for implementing and leading the world globally on the rights of indigenous peoples? Let's come up with a proposal. And so I had a chance to work with the State Department on a proposed framework around some of these basic principles. And one of the points that Kim mentioned was this is a two-way street. And what we want to do and what I really want to advance within NCAI is that point that consultation is a two-way street. Yes, we can sit and respond and react to the many Dear Tribal Leaders letters that we're going to receive to trigger consultation, but we also need to understand that that works the other way. We can set the agenda. We can trigger consultation on the issues that we would like to talk about at a date and a time and a place that we want to engage. The very first meeting I chaired as NCI president, I found that there were tribal leaders lined up wanting to ask questions of agency officials, and the agency officials, before they even got on stage, said, we're not going to have time for Q&A. And there was a significant question raised about the M opinions, and there was a thought that the M opinion at Interior may be withdrawn. Tribal leaders heard about that. They wanted to engage on that conversation, and there was some pushback. And I remember physically body checking to say there's some questions we want them answered. And so even at that level, there was some resistance to engage. And as NCI's president, I know we're going to be getting requests to consult at NCAI. They see that as a target-rich environment. Well, I've had conversations with our board, and I've had conversations with Chairman Wright's task force about utilizing our format, our platform. When we gather hundreds of tribal leaders, we should utilize that in a way that triggers consultation from our perspective to agencies. And we want to set an agenda rather than reacting to agencies piggybacking on our time. Let's figure out how we want to structure consultation on our agenda at our date, time, and place, and have our sets of questions. Because invariably when we consult, it's usually around a few set of questions, a very fine point, and we try to not only speak to the issues that they want to talk about, but also the broader implications of their inquiry to what's happening within our tribal nations. And so I'm really excited and encouraged that we have an administration that wants to engage in robust consultation. I think we have an opportunity, this generation of tribal leaders, to move toward that standard. And we need to take the time to do this strategically and not give them an excuse of saying we have this and this is meaningful consultation. We've got all of these boxes that we can check. We have all of these process, and we're going to report back. We're going to hear you. We're going to do. Let's come together to say this is a minimum. We believe that a relationship with the United States demands that the United States can no longer take unilateral action affecting our land, territories, and people without our consent. And then just set the agenda on how we are going to make advancements. And from my perspective, we were working locally here in the state of Washington. As was pointed out, we had a citizens initiative. We wanted to streamline and mainline the concept of FPIC. And when our governor, Jay Inslee, ran for president, he put FPIC in his platform. We've had legislation in our state legislature this year. So we are educating folks here in Washington state. Our Attorney General, Bob Ferguson, adopted FPIC effective immediately as policy 2 years ago. And so if we can work locally, and if we can work with agencies to populate agency after agency in iteration of FPIC, I've had conversations with some of our elders that have been around for a long time that pointed out we have iterations of consent. In NAGPRA, for example, we have iterations of consent, and we need to build on those because it's not rocket science, and it's a basic fundamental understanding. And so those are some things that I think we really have the opportunity in front of us with this administration to make some significant and meaningful advancements toward tribal sovereignty and lead not only in this country, but certainly with the United States globally, because while we're faced many challenges, there are indigenous peoples globally that are facing and risking life and death just to speak up to protect their ancestral homelands. And so when I look at this issue and making advancements on consent in our political stature here in the United States, I also know and understand that there are those indigenous peoples in northern Siberia, those indigenous peoples in the heart of the Amazon. They don't have political structure, and they're relying on NGOs and others to defend their interests. But as sovereign tribal nations in a country that wants to lead the world on this standard, we have an opportunity to not only secure our inherent God-given rights as sovereign nations for the indigenous peoples here in the United States, but the hundreds of millions of indigenous peoples globally. That is our mission, that is our charge, and I'm just really happy and excited to have this format and to continue to do the sacred work and important work that we know is necessary. Siakwel.
Thank you, President Sharp, for your words and for your powerful vision, going forward. At this point, I wish the webinar was going to last a lot longer than it is, but we're going to try and do as many questions and answers as we can in the next about 15 minutes. And to do that, I'm going to turn it over to Derek Dietzo, NCAI General Counsel, and he's going to address the questions to you all.
Thank you, Ryan. Appreciate it. Our first question is to Colette, Rutel, and Kim Tihi, and it involves whether or not you all believe that the UN doctrine of free, prior, and informed consent can be formally recognized in future tribal consultations?
Well, that's a really good question. Keep in mind that when President Obama support for the UN DRIP in 2010, that support has never been withdrawn. If you'll recall, there was also an accompanying document with that support that gave examples of what it means for the U.S. to follow the provisions included in the UN DRIP. That was done, by the way, because agencies were not familiar with UN DRIP and they didn't know how to implement it. And so we developed this document because, one, there were qualifiers in there. Two, to give examples. If you do these things, agencies, then you're following these provisions, right? I mention that because that support is still there, that accompanying document is still there. So there is a way to maybe revisit that accompanying document and to revise it and to get more teeth put into it. I mean, that I'll also say this too, the State Department had reluctance to engage in consultation because of the nature of its agency. And so they, with some arm twisting, did do so and to follow the spirit of the executive order on consultation. But I do think that there is an opportunity to consult widely when it comes to international instruments. State Department owns that, but the things included in the UN DRIP, including FPIC, also affect the domestic agencies. So when we ask the administration to alter, revise things, it's really including all the agencies. They are all stakeholders, and I'm not all suggesting that it can't happen, but with President Sharp's leadership and others, I know former Ambassador Keith Harper very much supports FPIC. There may be some momentum to, at a minimum, revisit the accompanying document and revise it for what the United States current meaning is of each of those provisions in the UN DRIP.
I think it's certainly possible for tribal leaders in this process right now, as agencies are working on developing consultation policies, to point to that and to point to the standard that we've all been talking about, you know, free, prior, and informed consent, and to try to use that language and the US's dedication to that to get a definition of consultation that's as close as possible to that. And so I think it's something that definitely tribal leaders should be emphasizing in this discussion.
Thank you both for those detailed responses. Our next question comes from Chairperson Aaron Payment from the Sault Ste. Marie Tribe of Chippewa Indians. This is a three-part question. Chairperson Payment asks, how can we ensure that full transparency from tribal leader comments during consultation are not distilled beyond recognition? Also, what can we do to ensure a bird's eye view is captured across agencies? And how can we institutionalize this process beyond the ebbs and flows of this presidential administration? And what role can or should the White House Counsel play to effectuate substantive follow-up and ongoing transparency?
I'll take a crack at those very good, tough questions. So with respect to full transparency, I think in all of the questions from the chairman that moving something towards a standard that's been outlined in the RESPECT Act is a way to get that full transparency and documentation of tribal concerns and documented responses of meaningful ways to address those concerns. And, from a process that requires, the consultations to be documented to the actions being taken, those robust process requirements, particularly built into statute and giving tribes rights as opposed to policies that may be unenforceable, I think is a critical part of this process for longevity and sustainability of meaningful tribal consultation processes. So I do think, there's a model, there's a framework out there right now that is the RESPECT Act that's been referred to as part of the campaign and I think is there that can be, highlighted as a goal through this consultation process to get through. But I do think at the end of the day, we need some statutory protections for tribal interests and to get to those objectives that the chairman highlighted in his questions. And I think the White House Counsel is going to be a key part of that process to message that at the highest levels of government. I think during our tenure in the Obama administration, one of the most rewarding aspects from my perspective was the true meaningful and engagement and interest of cabinet secretaries in participating in the White House Council, and not just in the tribal nations meetings that was held annually. There was great participation, but behind the scenes in the White House Council, there was an interest and a desire from cabinet secretaries. And we need that across the board, and we need that level of interest for the advocacy efforts to work to institutionalize some of these good processes.
And this is Kim. I'll just add to what Mike said. I do think there's some value with organizations like NCAI, maybe through consultation, where you come up with some uniform language, right? In every bill that's going through. I mean, we have reauthorizations going through on VAWA, NAHASDA, and you start inserting that in uniform language in every law. That way you have the thing that Mike was just talking about, uniformity, and how the agencies consult, because it creates a standard that they can't violate. Short of that, OMB has a little known office called Office of Information and Regulatory Affairs, OIRA. They oversee regulation, they oversee implementation of things like the presidential memorandum. So maybe what could also be an exercise in this administration is once the agencies bring in their agency plans, because that's who will house them, that maybe they pull and try to glean from these exercises in the consultation dialogue some uniform standard of what the agencies have to achieve. Yes, they have their agency plans on how they want to move forward on consultation, but maybe through each of those agencies, they can come up with some uniform standard that each will have to, comply with. So that's my response.
I guess I would just add to the chairman's questions and to what's already been said. I think as we work through this initial phase of consultation, it's going to be really important for us to have a very clear vision from tribal nations on what constitutes meaningful. And to some of the issues that I raised earlier, in my mind, a meaningful consultation does require that we exercise consultation as political equals. And that does mean that we advanced FPIC as a minimum standard. And I used to think that we wanted to achieve political equality with the United States, that they were somehow up here and we needed to achieve political equality. But I've come to recognize we are here with the rest of the world. The United States is the last country. They need to come up to this level. And so meaningful consultation means government to government relationships where we're at the table as political equals and sovereigns. Anything short of that is not meaningful. Anything short of that it's robust. It's certainly active, respectful consultation, et cetera. But anything that does not acknowledge that we are at the table as equals is not meaningful. And I think that's a basic principle that I would add that we have to do. We don't want to give them an excuse with a very outline process that this is meaningful. We just don't want to let them off the hook that easily.
Thank you all for those wonderful answers. The next question in the queue is, do the panelists today have any suggestions on steps local governments, cities or counties could take to create opportunities to consult with tribes? What role do local governments have in helping to uphold tribal treaty rights and interests in their work?
I could take a shot at that from my perspective as a tribal leader. We did work with Attorney General Bob Ferguson's office on consultation and consent before he adopted it. And I had an engagement with our governor, and we just came off of the culverts case. At that time, the state of Washington had been involved in 11 treaty rights cases with tribal nations. We were 11-0. And so I called out the governor to let's close this dark chapter of treaty conflicts and open a new chapter. And I talked about FPIC. Our attorney general wanted to hear more about it. That following spring adopted it as a policy. Now the city of Seattle is considering that. And so from our attorney general's perspective, he saw it as a basic, not rocket science policy and can be implemented at an agency level. So I would really recommend looking at some of the existing FPIC and consultation policies that do encapsulate a measure of political equality. But those are two examples that we have in the state of Washington. And I know Bob Ferguson sent letters out to other attorneys general, so I don't know if others are following suit, but that would be a good place to start.
Yeah, I mean, there's no reason why the state can't engage in the same consultation process the federal government, has engaged in. And while there might be different legal bases, for example, the federal government has frequently delegated its responsibility in certain areas like education to the states, and then they're really stepping in the shoes of the federal government and providing some of those services and should be bound by the same trust responsibility. But even outside of those narrow areas, it just makes sense to negotiate, to consult with your neighboring governmental entities. In Minnesota, I think you can see how smooth that process worked once our lieutenant governor was elected, Peggy Flanagan. We're in the middle of the pandemic, and Minnesota has done quite well in coordinating with tribal nations regarding making sure that both the state and the tribes have say in terms of shutdown orders and restrictions, and that they both respect each other's space, and that they're both sharing information, and they are treated as equals. And then obviously our neighboring state, South Dakota, has been less successful in that. So I think it goes to some of the earlier presenters saying you need to have people in federal agencies that really understand tribes and that represent tribal viewpoints, not just in the Bureau of Indian Affairs. And we can really see in Minnesota how having representation, with somebody who's the second highest executive branch official, who's also a citizen of White Earth, has really made a difference in building trust, and then also getting tribes at the table in terms of being able to consult with the state.
I would like to add to that. Thank you, Colette. I would just like to briefly add to that. That is part of a strategy and agenda for us to actually achieve FPIC. I think populating the local jurisdictions to prove it's not something that's difficult. It's not something that's going to give tribes special rights. It's actually going to work. It's actually going to be effective. And then while at the same time populating federal agencies to the extent they can adopt some semblance of FPIC, and then in foreign policy, it's that way in which we broadly advance FPIC locally within federal agencies, internationally, that we create that groundswell that's actually going to help our generation of tribal leaders move and advance it. So we need to think about it in a very strategic way at all levels. It's a full court press, and we have just a phenomenal opportunity at this time.
Thank you both for those answers. Oh, go ahead, Mike.
I was just very quickly, I was just going to add, I think it's all about political power. And the more, whether it's tribal representation and the state or local jurisdictions, or whether it's just the economic and organizing wherewithal that tribes have in those local and states, I think you see people wanting to understand better tribal interests and the willingness to consult and to work with tribes. I think you see that in Minnesota, you see that in Washington State, you see that in New Mexico. And if that can expand, then I think we'll see more state and local entities not having that same legal responsibility, but from a political standpoint, wanting to engage with tribes and protect those interests.
And then Ryan, if I could just add to, just from our own experience at Cherokee Nation, we're pretty robust about joining city boards and commissions, state boards and commissions, because we have a voice then, right? Yes, you can strive to have a relationship independent of doing that, but we do try to participate and in the local chambers and such, and so that we are at the table when decisions are made, because oftentimes, especially on the local level, folks are not as educated. They don't know whenever they're infringing upon a travel right, or if an issue comes up that requires consultation. So we are often put ourselves in a position where we're at the table.
Mhm.
Thank you all for those answers. This has been a really powerful and amazing discussion, and it's unfortunate that I have to be the one to end it at this point in time, but I want to be respectful of everyone's time. So I do really want to thank all 4 of our panelists for being here today. I want to thank all of NCI staff who we couldn't have had this event without your help in making it happen, as well as everyone who submitted questions, everyone who's in attendance. We have a long list of questions we did not get to, unfortunately, but we are taking those down, and we will do our best to get some sort of information out to everyone via email at some future point. Before we go, let me just make a few quick reminders. This webinar has been recorded, and we do intend to put it up on our NCAI YouTube page very shortly. The address for the Consultation Support Center is also on the screen on NCI's website. You can get to it from there as well. And my contact information is also on there, but there's contact information for all of the NCI staff on our website. So if you have additional questions or concerns or comments, please do get in touch with us. And with that, I just want to thank everyone for attending. Thank everyone for your time. This has been an amazing discussion. Thank you.